Winging it is not an emergency plan. Make sure your kids know what to do during an emergency, who to call, where to meet, what to pack. Visit ready.gov/kids for tips and information. A public service announcement brought to you by FEMA and the Ad Council.
Lupus. It's one of the cruelest, most mysterious diseases on Earth. Lupus strikes without warning, can ravage any part of the body, and has no known cause and no known cure. Its health effects range from a skin rash to a heart attack. Lupus is an unpredictable and misunderstood disease that's difficult to diagnose, hard to live with, and a challenge to treat. Help us solve the cruel mystery. We're the Lupus Foundation of America, the only national force devoted to solving the mystery of lupus. We lead the fight to improve the quality of life for all people affected by this devastating disease. To learn more about lupus and how we can help those who suffer from its brutal impact, visit us online at lupus.org or call the Lupus Foundation of America at 1-800-558-0121. That's 1-800-558-0121.
Hi, I'm Judith Light. So there you are. It's flu season, and you're over 65 like me. You're having another busy year. So much to do, so many roles in life to play. But you feel like you might be forgetting something serious. Your annual flu shot. And before you know it, it's too late. It's not just the aches, fever, and chills that last for days and days. The flu can be life-threatening, especially if you have chronic conditions like diabetes and heart disease, which can worsen with the flu. Being active and healthy alone won't protect you. The immune system weakens with age, making you more susceptible to the flu. If you're over 65, ask about your vaccine options, including one made specifically for us. An annual flu shot is the best way to help keep the flu away. Visit the National Council on Aging at ncoa.org/flu to learn more and talk to your doctor or pharmacist about vaccine options for people 65 and older. Again, that's ncoa.org/flu.
Talk 1470 is WWNN Pompano Beach and 95.3 FM W237BD Boca Raton. The Health and Wealth Radio Network, 1470 AM and 95.3 FM. The Health and Wealth Radio Network. Don't miss Lisa Macy with The Justice Hour, Tuesdays at 1 p.m. and Saturdays at 3 p.m. WNN.
Avoid probate with a revocable living trust. $350 for single people, $450 for married couples. When you complete your trust with attorney Barry Siegel, he will give you a $100 gift certificate to Tavolino Italian Restaurant in Coral Springs. The Siegel Law Group, with offices throughout Broward, Palm Beach, and Dade County. Call toll-free 1-855-FLA-3782.
A bad back, heartburn, low libido, stiff joints, not sleeping well, got allergies, need to lose weight? If you want to feel better, please tune into my health talk show Sunday mornings at 10, the Dr. Bob Martin Show on Talk 1470 WNN.
Talk health, talk wealth, talk politics, talk 1470 and 95.3 FM WNN.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. Welcome to the Ask the Expert Show with local celebrity host Steve-O. Sit back each week while Steve-O educates you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O with today's expert in their field.
Hey, welcome to another Ask the Experts. This is the first Thursday of the month, so that means it's time for Community Association Law, our show that gets more calls than any other show we do. And we have an hour today. If you'd like to call in, this is our Community Association Law with Kay Bender Rimbaum. They've been with us for about 3 years now. If you've got a question, 888-565-1470, 888-565-1470. And let me introduce you to one of the senior partners, Robert Kay.
Hello, everybody.
Good afternoon. This is weird because Michael's not here today.
No Michael Bender today.
Michael Bender's usually with us. The law firm is Kay Bender Rimbaum. So you get to do all the answers today, and we got to start off. This is something you do every show we do, is tell us about your firm.
Well, K. Bender Rembaum is a full-service law firm, but primarily focusing in the area of community associations, representing condominiums, homeowner association, cooperatives, and all aspects of the operations of the community, dealing with review of the documents, covenant enforcement, collection of assessments, contract review, negotiation, amending, anything that comes across an association day-to-day operation is the legal services that we provide.
This is about 90% of your
90
business?
plus, sure.
90 plus?
Yeah.
That's important. The reason why I bring that up, there's firms out there that handle 5, 6, 7 different areas of law, and this is a specialty. This is mostly all they do. We've already got our first phone call.
Well, that's
Can we
good.
go to it?
Sure.
Let's go to Margaret. Good afternoon, Margaret.
Hi, can you hear me?
Yes, we can, loud and clear. Do you have a question?
Yeah, I have a question that came up the other day. I'm on a board in Palm Beach County, and I know it's kind of I don't know how to put this, but we have a transgender teen downstairs in a common area, in the pool area, doing lewd things. And people were complaining to me about it, and I didn't know if I had the jurisdiction to say anything. And how do you handle a situation like that, and what are the laws? It was around the pool, and I don't know. I've never had this problem before, but I got these calls about this couple.
You say it's a teenager?
Well, either that or in the early 20s. They're the daughter/son of an owner who doesn't live there with them now. The owner's not there, but it's one of their children.
And this person is the only occupant?
We don't know. We don't know how many people are living in that unit, but apparently there's 2 same-sex people down there, having a relationship in front of everybody that can overlook the pool. And we have many older, seasonal visitors, and I don't know that they think, they're just doing it to make a statement. I don't know what the deal was, but I didn't touch it. I didn't go down. Somebody went down and asked them about their drinks because they're not allowed to have glass or something. So I was just wondering, what are the laws about something like that, and how much, exposure do you have if you confront somebody doing those kind of things in a common area?
Well, the aspect of being transgender or homosexual or anything of that nature is not really a factor in how you deal with the situation, because it could happen with heterosexual individuals as well.
Right.
I imagine there are rules in place regarding conduct within the common properties, if not specific rules that have been adopted by the board. Provisions in your governing documents that don't allow nuisance activity on the common areas. If there are these types of things, it would be treated in much the same manner as any other violation, and you can pursue legal action to compel the individuals to stop the conduct in the public areas.
Okay, so it has to be in the docs, saying that you can't have a nuisance going on in a public area, and this would be considered a nuisance?
You do need something to hang your hat on if you're pursuing legal action, either in your governing documents or as a rule that's been adopted by the board that is an enforceable rule relative to that type of situation. Now, if they're just kissing, hugging, that kind of stuff, that may not rise to the level that would be legally actionable.
I think that's all it was, but it was excessive, and it went on and on and on.
Well, if it was a heterosexual couple doing it, would it be considered offensive by the people who are complaining, and would they complain as well?
I think it would be, because nobody does that in our building, but the thing that I was curious about is how much exposure do you have if it's not a heterosexual couple, where you're going to be accused of all kinds of prejudice or whatever they're doing
discrimination
nowadays.
Would be the claim that would be made, and it's certainly a possible claim that could be made if that's the primary driving force, which we would never recommend it be. So
No. I don't think that had anything to do with it, but it did add a layer of concern to people that are not used to that or weren't expecting that in the older community. So I don't really know what their thinking was other than what's going on here, and we have to call the board and complain about it. You know?
Now, is your community housing for older persons, or is it open to everybody?
It's all ages.
All ages,
but there's
okay.
a large older population in there.
Sure. Well, if the association has an attorney, I recommend the board consult with the attorney to go over the specific facts that you're dealing with, and they'll have the benefit of your documents to help go through that with you and advise you as to the best course of action to get them to comply.
Okay, now we do have, I would say, a need to update a supplement or whatever you want to call it, an amendment to occupancy rules, which are kind of vague. And so is that something when we update our documents, we could put that sort of thing in there?
Definitely could, and you don't have to wait till you do a big project. You could address it at any time. If the association does not have counsel, our office would certainly be available. You can call us at 1-800-974-0680 and arrange for an appointment to meet with one of the attorneys of the firm to help address that, no charge for initial consultation, and we can see if we can help you through it.
So you can bring your docs in and say, we want to update this section of our docs. What's a fee schedule? And
Absolutely, yes.
Oh, okay. Well, thank you very much.
Well, thank you for calling.
Thanks, Margaret.
Keep listening.
All right, sure.
Well, you
Bye-bye.
got to kind of tiptoe that one, don't you?
Well, certainly when you're dealing with issues that are protected classifications, both federal and state level, it is quite often a knee-jerk reaction for people to claim discrimination, and these laws are there to protect a large number of people and are tending to lean over backwards to that protection, and it's a situation where you're often guilty till proven innocent, so it's best to avoid situations that could lead to claims of discrimination.
We were just talking about the firm. So now your firm, you handle cases in Dade, Broward, which is where one of your offices are, Palm Beach, where another one of your offices are. So you cover almost all of South Florida.
Well, yes, we go down into the Keys. We go all the way up to Daytona and beyond, and across into Naples and Tampa area as well. And we're growing, so we're covering a good portion of the state.
If you'd like to call us here, if you have a question for Robert, the phone number here is 888-565-1470. The name of the firm is K. Bender Rimbaum. You also have an incredible website. I want to bring that up because you can actually go to your website right now and watch our show live.
That's right.
Give everybody your website.
The website is KBR, the initials, kbrlegal.com. And click on the tab that indicates the TV show, and that would take you to, or the radio show, sorry, and that would take you to the live audio and video. And anytime during the week, if you're unable to do so now, if you want to go in, it's saved to the website. You can see this show, you can see past shows.
And don't go to the website and not read Legal Morsels.
Legal Morsels is a
that
good
must
tool.
be one of your signature links on your website.
It is. It's a good tool. Under resources, we have Legal Morsels, where we have articles of topical interest. We also have Rembaum's Association Roundup that Jeff Rembaum puts out articles on at least a bi-weekly basis, and there's many, many articles there, and you could probably spend hours going through them and not get through them all.
Well, there's something on there now about a new law. So, and you just tell me there's several new laws that have come out of Tallahassee.
Well, there are 3 in particular that have been passed by the legislature so far this session that have been sent on to the governor. Of the 3, 2 of them are, in a sense, combined in one of them. They're House Bill 653, House Bill 1237, and Senate Bill 398. Now, House Bill 653 incorporates a large portion of what House Bill 1237 contains and has a few extra things. House Bill 1237 has 1 or 2 items that is not in House Bill 653, If the governor signs both, they merge them together, and it's seamless, so you wouldn't notice the difference. But between these various bills, you're talking about 150 pages of legislation, primarily in the condominium arena. There's a little bit for cooperatives and homeowners associations, but those changes are more bringing those statutes in sync with what is already in the condominium statute on the topics that they're talking about.
So it should get passed.
Right. The Senate Bill 398, which was the first one that was passed, is what we refer to as the estoppel bill, and it
That doesn't
provides
sound good.
it provides restrictions and requirements on what is known as estoppel certificates are required to have. Estoppel certificates are documents that identify assessments that are due to associations when the property is being transferred from one person to another. And the statute, the people in Tallahassee decided that they needed to create laws to identify what has to be in there and how much can be charged for them. And they've increased the amount of information that associations are required to provide. By its name, estoppel certificate, everyone looks at that as dealing with just assessments. What assessments are owed, and that's basically it. And once you provide the information, if they close the property sale based upon that certificate, the word estoppel means you're stopped. You cannot ask for more. So that's basically the limit of what you could ask for. Now the statute's requiring other information to be included, such as any potential violations that are existing on the property, names of who the association attorney is, and then some legal information, such as whether or not the association has the right of first refusal. The board has to approve the seller or the purchaser, and things of that nature. So it's likely going to result in increased costs to associations while providing more information to title insurance companies, which was the driving force in getting the statute passed.
Okay. We're going to go to break right now, and it's going to be a short break. We come back, we've got a phone call.
Okay, hang in there.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. Today is the first Thursday of the month, so that means K. Bender Rembaum, Community Association Law. We've got a caller on the phone. Sarah. Hi, Sarah.
Hey, guys. How are you?
Good. How are you?
I'm good. I have a question if you guys have a second.
Oh, Robert's got a second.
That's why we're here.
So I live in a condominium, and I'm wondering if a board can levy late fees on quarterly assessments that are delinquent, and if so, what's the process of enabling a board to do that?
Okay, in order for the board in a condominium to impose a late fee against a delinquent assessment, the authority to do so has to be in the governing documents, either in the declaration of condominium or in the bylaws. We recommend it be in the declaration because that's where the lien entitlement is, and if you want to be able to include the late fee in with the lien, it should be in the declaration as well. So if the governing documents do not contain the authority to impose a late fee, then the association would not be acting correctly if it did charge such an amount. Now, the late fee is also limited to the greater of $25 or 5% of the unpaid assessment. So usually it's $25, and that's one time. So if it's late in January, you get a late fee for January. It's still not paid in February. You don't get another late fee for January, but you may for February. Associations can amend their documents to incorporate that. Or if they choose not to, then they would not be able to.
So the board can't just establish a fee by passing a resolution or anything like that. Someone was telling me that they just need a quorum and then they can do whatever they want, basically.
No, if it's not in your declaration or bylaws that you can charge what they call administrative late fee, then for the board to do it by itself would not be in compliance with the statute, and that would be an incorrect charge. For all of our association clients, if the board has done that either on purpose or by mistake, we will evaluate that before we do any collection work for them and let them know that we're not going to include that in the amounts that we're pursuing.
And let's just say they have done that because it's a relatively uninformed board. Is there any penalty associated with it?
Well, if they do that and pursue collections on it, in all likelihood, that's going to be a basis to overturn the association's claim. They could lose and have to pay the legal fees of the delinquent owner, and while still not being able to collect the actual maintenance assessments. That would be a worst case situation. But as far as penalties to the board at this point, the law doesn't provide anything specific that would do that, no.
Okay. All right. Well,
does that answer your question?
I appreciate it. Yes,
thanks so much for calling.
All right, Sarah, if the board needs help, have them call us.
I certainly will. Thank you so much.
Thank you for calling.
Give that your phone number.
We can be reached at 1-800-974-0680. That would allow access to both our Pompano Beach office and our Palm Beach Gardens office. And obviously people that are further north would prefer to be dealing with Palm Beach Gardens, but sometimes they don't. And we're available in both offices throughout the state.
I got an email the other day from a new listener who kind of came down on me. He said, I don't introduce you enough. He said, he said, I don't get in my car right at 5 o'clock, and it would be nice to know who's on our show.
So every 2-3 minutes, we'll say my name and phone number?
About every 30 seconds. But anyway, this is the law firm of K. Bender Rimbaum. They are a community association firm. Today we have Robert K. We usually have also Michael Bender with us. And just real quickly, you have offices.
Sorely missed Michael Bender.
Yeah.
Offices in Pompano Beach and Palm Beach Gardens. Conveniently located. The firm has been providing these services for continuously the past 25 years. I've been doing it myself longer, but for this firm, that's been my time, 25 years.
You know, I like bragging on you about something. If I were a board member, first of all, I don't want to feel like I'm stupid. I don't understand what you're saying because, I'm a board member. I should understand. But you make it so easy to comprehend, understand. You don't talk over people's heads. I enjoy because I think the area of law you practice is so interesting and it involves a lot of people.
Well, it's interesting and it evolves all the time as we see that we've got 3 new bills this year. Last year there weren't any, but typically every year there's a change in the statutes. There's regularly case law that is being decided by the various courts throughout the state that are involving community association issues. We report on those in our legal morsels and our Rembaum's Association Roundup. But it's always been a philosophy of the firm that our clients are lay people for the most part, volunteers serving on their boards, and they need to be able to understand what it is that they're asking for answers for and how it affects them in a way that is not requiring them to then go find a dictionary or find someone to interpret what the lawyer wrote. We try and make it clear, concise, and, of course, cost-effective, and we do it in a time-efficient manner as well. If you call our firm with an issue as a client, we get back to you the same day, unless it's later in the day, if possible. All inquiries are replied to promptly. You don't wait 10 days, 2 weeks, 3 weeks, and not know what's going on. We're always giving you the information you need quickly and effectively.
I thought the first time I came to your Pompano office, I said they must be having a huge meeting here. There were so many cars out there, but that's every day with you guys because service is very important to you.
We have a good amount of staff. The staff is also specialized. We have those who work in the collection arena. We have those who work in the foreclosure arena. We have those who work in the litigation arena. We have those who do the general work. So there has different staff people for each of the areas that are important to our clients.
Now, if I have a property, say, in Aventura, would you actually come out there for the first time to sit down and talk to us?
If the board desires, or the board is welcome to visit us at any time and see our facilities and how we provide the services that they want. Either way, we go and visit our clients at no charge for initial consultations, often at no charge when they've been long-term clients.
How long does the initial, when you first sit down with someone who's looking at your firm, how long is that? Is that an hour?
It's supposed to be an hour, but
yes,
quite often it goes beyond, and it really depends on what's going on. Everybody's got different issues and things that are more important than others, and sometimes they're facing litigation, they're involved in litigation, they've got many issues that they're either unhappy with their counsel or they don't have any counsel, things of that nature.
Well, you've got a fairly big firm. So can an association contact your firm for maybe they have someone, could they bring you in and sit down with you also as a second opinion?
There's no limit to the number of attorneys that any association can hire. In fact, when they...
But I'm talking like for a second opinion.
Certainly, we give second opinions all the time, and quite often after they've received the second opinion, that might inspire them to make us their primary counsel as opposed to the second opinion counsel. But either way, there are many qualified and competent attorneys out there. We just like to consider ourselves among the foremost in providing the service and expertise.
Hey, let's go to our next caller. We have on the phone with us Lita.
Hello, Lita.
Hi, Lita.
Hi there. How are you this afternoon?
We're doing fine. Do you have a question for Robert?
I do. My question concerns the operation of reserve funds in a condominium.
Okay.
I'm curious if there's a new law that's been passed that allows a condominium association to take money out of one reserve fund to use for the purpose of paying for something that was done out of another reserve fund. In other words, if we're painting and we don't have enough money in the reserve fund, can we vote as owners to take money out of the paving fund to put it in the painting fund to use that money for painting?
Okay, well, there's no new law on that, Lita. That's been the law for a great many years, and the answer is yes. Reserve funds are required to be held for the purposes for which they are reserved unless there's a vote of a majority of the unit owners present at a meeting at which a quorum has been attained to use those funds for a different purpose. So if you're doing painting, you don't have enough money, you want to draw from roofing or paving, then you would have a vote of the owners. And once you establish your quorum, a majority of those participating can approve that transferring of the funds. Now, that would be generally a permanent transfer. So now your other reserve you've drawn from is going to need to be reallocated in the following budget year to make up the shortfall over time, of course. But that's a consideration unless the owners vote to do something less in the following budget year.
Well, they're talking about just adding it to, quote, our maintenance next year, which I'm not looking forward to. I'd rather just have it as an assessment, not to bunch it in with our maintenance.
What are they talking about adding to your maintenance?
Exactly, because then when people go to buy and you have a high maintenance because you're using an assessment in the maintenance, it kind of scares buyers away, I would think.
Well, that can certainly be a consideration, but sometimes doing special assessments every year also can scare buyers away as well if you're not budgeting enough.
Does there have to be a meeting, or can this voting be done by signing a letter that says I agree?
It can be done by a letter by written consent if your bylaws authorize taking action by written consent. That's a quirk in the condominium statute, that the bylaws have to authorize the ability to take action by written consent in order to be able to do that. But if you do it by written consent, if you do it by written consent, you're going to need a majority of all the owners in order to pass the issue, as opposed to a majority of those present at a meeting where you have a quorum, because there is no ability to have a written consent of a quorum. You'd have to meet that quorum number. It's a technical distinction. So it may work best to have a meeting and use proxies so that you're able to at least get that majority number for a quorum and then do it that way.
Oh, that would have been the easy way. They're not doing it that way. They're going around knocking on doors, so they've gotten too late. For the assessment has to be done too quickly for them, I guess, to call a meeting. So they're just asking people to sign a letter that agrees to let everybody take the money out of the other.
Well, it's important that they get that vote, because if they use the money improperly, then they could be subject to complaint with the Division of Condominiums and potential punitive action in that respect. Now, there is another method of doing reserves that could avoid this requirement, and that's called pooling reserves. The statute and the rules of the division allow for the pooling of reserve, which means you take the statutory items, the paving, painting, roofs, and anything over 10,000, and lump them all together, and then you're using just a pool of funds, but you have to make sure that there's enough to cover the things that you need. That will take a vote of the owners to switch from the straight line method to the pooling method. And each method has its own pros and cons, and it's a good idea to speak with the association's financial advisor, its accountant, before making that final decision on whether or not to do that.
Gotcha. Well, none of that is going to be is going to have anything to do with us, because they've waited to the last minute to do this. So there's no time to have all these meetings. They've already had half the buildings painted, and now they're trying to put together the funds to pay the contractor. So it's a little bit sketchy here.
Well, if they're going to do a special assessment, they're going to need a 2-week notice in order to do that.
14 days, right?
Right.
Okay, thank you
Thanks,
so
Lita.
much. It cleared it up a little bit for me.
All right, Lita, good luck with that.
Hey, we're going to go to a quick break, then we've got Norma when we come back from break.
Hang in there, Norma.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we're back. Let's see, do we still have Norma? Let's go to Norma. Hi, Norma.
Hello.
Hi, Norma.
Hi, how are you?
Great. How are you?
Great show.
Thank you.
I'd like to know, you're clarifying for me, what is a material alteration in the building? Does it include painting, the colors of the paint, the decorations, like a backyard change from clear spaces to open spaces to child and barbecue? What is considered a material alteration? And is it enforceable?
Well, those are great questions, Norma. The statute for the condominiums provides, and this is not an HOA issue the same way. The condominium statute has something the homeowner association does not. It says there can be no material alteration or substantial improvement to the common elements except in the manner provided in the documents. And if the documents are silent, then upon a vote of 75% of the owners. Now, some documents provide for a percentage vote of the owners. Some documents will tie it to a dollar figure. If it doesn't cost more than $100,000, the board can decide it. But if it costs more than that, then it takes a vote of the owners. There's also a technical exception under case law that if the issue involves what is considered necessary maintenance, that means that it would not be a material alteration and would be accomplished by the board vote alone. So that's the basic law of it. To get to the more practical aspects, there are case law decisions that says any, and this is a difficult, they use legal words, palpable change to the appearance of the common elements is going to be considered a material alteration. And so what does that mean in real terms? One of the examples you gave, if you have some open spaces and you decide you're going to pave it into a parking lot, that is a material alteration. The real difficult issue is the color of the paint on the exterior of the building. There was a case in the late 70s. The name of it was Islandia versus Vermont. In that community, it was a multicolored concept. There were sections, that each section was a different color. One day the board was repainting, and they decided to paint them all the same color, and Mr. Vermont didn't like that, so he brought a lawsuit against them. And ultimately, the Court of Appeals said that because the color was a material aspect of the community development, changing it there was a material alteration that required a vote of the owners. Okay, the Division of Condominium heard that. They heard change of color, material alteration, and decided any change of color is a material alteration. So if the issue comes before the Division of Condominium, then any change of color on the outside is considered a material alteration. If you were white and you go to beige...
What about inside in a lobby?
The lobby is a little different because not all of that is necessarily common elements. You have furniture, which is real property. Changing the color of the walls in the lobby could be considered certainly a material alteration under that same scenario. Changing the color of carpet may not be, because carpet is carpet, and that's the real concern. If you take out carpet and put down a marble floor, that's a material alteration. If you change one carpet to another, the color change would not necessarily be a material alteration, particularly if you can't even get the color that used to be there, which quite often is the case. Necessary maintenance is another analysis that you need to do when you're looking at the issue. And so it's not a simple issue as we would like it to be, but it's definitely one that is treatable, for lack of a better word. So you got to look at your documents as to what your requirements are for voting, if voting is necessary. Sometimes it's not necessary at all, and the board can just make the decision. So you check your declaration to see on that.
Well, our declaration states that $100,000 to maintain and all this stuff, but it doesn't mention the words material alterations. Does that make a difference?
It's hard to say from what you've described. I'd need to look at the whole set of documents to give you the best answer on that, but it's possible. And then it may require a 75% vote if it doesn't mention it at all.
No, it doesn't mention it at all. It just says to maintain or to fix or repair or all these other words, but it does not say the words material alteration. And I think it's a different, to me, my opinion is that it's a different matter, because one thing is to change or to fix and do everything else, and one of them is to change what you have to something else.
So
like
I'm
in the
gonna
Cape
guess.
backyard, it's an open space, and people like the open space, and they decided they're going to put a play yard for the children, and they're going to put barbecues out there.
Well,
Well, it happens that I'm on the second floor, and I'm going to get all the smells and all the noise.
Norma, I'm going to take a guess, and I'm going to say your documents might be from the 70s.
The building is 20 years old.
Okay, so not that old. Okay, but if your condominium was built in the 90s, then there should be a provision that identifies the issue of material alteration, because they generally do from that time period. But if you're concerned that they're doing something that they shouldn't be, your best recourse is to notify the Division of Condominium of the activity that's going on, and they will investigate and advise the board if they're violating the statute in that respect.
The only problem is that when I call, they tell me that if I put in a complaint, I have to file a complaint, and if I put in a complaint and they win, I would have to pay for their attorney's fees.
Well, not if you go to the enforcement section in Fort Lauderdale. If you file an arbitration case and you claim they're doing something wrong in that respect, that's a possibility. But if you file a written complaint with the division in its enforcement section, there is no prevailing party, there is no attorney fee issue from you. The division basically takes it and runs with it.
The Division of Condominiums?
Yes, there's an office in Fort Lauderdale. You can either check with the, just do a Google search on that, or it's in the Department of Business and Professional Regulation, which has a website out of Tallahassee, and then the Division of Condominium is part of that.
Okay.
Give them a call, and they might be able to guide you a little better.
Yeah, because I don't want to get stuck with a bill who knows how much, you know?
Can't blame you for that.
Okay, thank you, Norma.
Thanks for listening.
Thank you very much for your answer.
Thank you.
Bye-bye.
Do we still have Marilyn on the phone? Let's go to Marilyn, then we got some classes to go over.
Yes, we do. Hello, Marilyn.
Okay, I could make this quick because I have to tell you, it's about me getting on a board, but after I've been listening to the show all day, I don't know if I still want to, but I'll ask my question.
Well, considering some new legislation that makes certain conduct on the board subject to criminal prosecution, you may want to think about that.
I know, so, but I'm going to go ahead and ask so I know. So there's 2 openings for directors, and they're going to have an election. So I got my paperwork in on time, and somebody else got their paperwork on a time. Okay, fine. There's 2 of us. There's 2 spaces. But now a third person has said he's going to run, and he submitted his. So I called our management company, which isn't you, and if I get elected, that will change. But anyway, called them, didn't hear anything. So I went to the current president, and I wrote this down. He said he will waive Section 718.112.4A so that this guy can go ahead and run. So can he do this?
No, he cannot. The statute provides that the only individuals who may run for the board are those who submit their name into candidacy no less than 40 days before the election. If he did not submit his name by that deadline, including him on the ballot subjects the election to challenge through the Division of Condominium in the arbitration section, as well as in the enforcement section. But you only have 60 days from the election to file a petition for arbitration. And if you're going to file a petition for arbitration, you also need to send a demand letter to the association first in order to meet certain statutory requirements to qualify for arbitration that says if they don't fix the problem, then you're going to arbitration. So make sure that's included. But you can tell the president that he's subjecting the association to potential legal action that could result in a significant expense, and that maybe he should reconsider and follow the statute.
Okay. Well, now you've told me that. I will run because he's not going to be the president for long.
Well, then, Marilyn, we hope to hear from you.
Okay, thank you.
Thanks so much. Good luck to you. Hey, let's go to break. We come back. Let's go over all your classes.
Okay.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Okay, and we're back. We have here today, again, live in studio, Robert K. He's the senior partner of K. Bender Rembaum, their community association law. You can go to their website and actually watch today's show if you missed it. You can go back later on and watch it. Give them your website.
It's KBR, the initials, kbrlegal.com. And there should be a tab for the radio show. You can go directly to that, and then there's a video that shows us. Hello, everybody. And many other things on the website as well.
Okay, so now you're going to tell us the classes first?
Yes, we'll go to the
and
classes.
And we're going to get to Matt.
Matt, don't go away, Matt. Okay, for the month of May, we have on Tuesday, May 9th, in our Pompano Beach office, the Condominium Association Board Member Certification, all free. The board member certification we've talked about in previous shows. It's a requirement for board members in condominiums, homeowner associations to have this certification. There's two ways to get it. You can sign a piece of paper that says you've read the governing documents and will abide by them, or words to that effect. Or you could go to a certified course from the Division of Condominium, of which ours are. So you get good information. It's suggested to take the course because it gives you a lot more information. It helps to open your eyes to things that you're facing while on the board. So May the 9th, we have the board member certification in our Pompano Beach office. And on May the 10th, we have the Homeowner Association board member certification in our Palm Beach Gardens office. The Pompano one is at 6:30 to 8:30. The Palm Beach Gardens is from 6 o'clock to 8:30. And you can go to our website at kbrlegal.com in order to find out more information on how to register and get a spot reserved. Light snacks are served, so you want to be sure to RSVP and get your name on the list. The space is limited. On May the 16th, from 6:30 to 8:30, at the Tamarack Community Center, which is located 8601 West Commercial Boulevard, we are having two separate courses, one for condo board member certification and a separate one for homeowner association board member certification. Both are starting at 6:30 till 8:30 at the Tamarack Community Center. Two separate courses taught by attorneys from our firm in conjunction with the city of Tamarack. So do come out to that if you're out in Tamarack. It's not limited to just Tamarack people. So you can look on our website for that, or you can RSVP at kbrlegalseminar@pearsongrant.com or call 954-776-1989, extension 242 for more information and to register yourself for that, or contact our office at 800-974-0680. Then on May 17th, we have the Condominium Association Board Member Certification in the Palm Beach Gardens office. And the last one in May is May 30th. A new course we're offering for 1 hour of credits is guest restriction and screening, tenants and new owners. Is it worthwhile? This is a course that managers can take for credit, and it's one credit, but it's full of good information on dealing with guest restrictions and reviewing new owners and tenant applications for those communities that are available to do that. So that's on May 30th in the Pompano Beach office at 6:30 to 7:30.
Okay.
So those are the courses for May.
All free.
All free, all light snacks. Although it's good to reserve your spots so that we can be sure to accommodate you. Hopefully Matt's still waiting.
Yeah, let's see if we can go to Matt, see if he's still there. Hi, Matt.
Hi, how are you?
Oh, thanks for waiting, bro.
Thank you for taking my call.
You have a question for Robert?
Yes, I'm trying to get some clarification with regard to what the president of a condominium association or a homeowners association can do with regard to voting. Can the president of the condo association or the homeowners association go ahead and make a motion, or can they go ahead and vote on a motion made, being that they are members of the association?
Okay, assuming the president is a director, because we're talking about at board of directors meetings, correct?
Mm-hmm. Yes, sir.
Okay, so assuming the president is a director, you're wearing different hats. You're the president and you're a director. They're different hats, different roles, but can be worn by the same person. Assuming the president is the chairperson of the meeting, under Robert's Rules of Orders, which is typically what your documents tell you should follow as you can. Under those rules, the president doesn't make motions, they entertain motions. If they want to follow the formalities of it, they could give up the chair to make a motion and then retake it, so long as there's a second. Many communities don't follow the formalities so carefully, so the president will make motions. So long as there's a second, it's properly taken up. It won't invalidate the action that's taken. Courts aren't all that critical about applying those technical formal requirements. It's really more to help order. But more importantly, as a director, the president is required to vote on all issues that come before the board in the same manner as any other director. So while there may be technical issues as to whether or not to make the motion, they can certainly vote on and should vote on every issue unless they have a personal conflict of interest of a financial nature. So if the contract or the proposal that's before the board involves something that will have a potential financial effect on that director, either pro or con, that director should then abstain from voting on that issue. But otherwise, the president should be voting on everything.
Okay, so it isn't that he only votes in the place of a tie.
No, that's more governmental, primarily in the Senate.
Great. That's what I wanted to be sure of.
Okay,
Thank
Matt.
you very much, guys. You have a great evening.
Thanks a lot.
As well. Thanks for listening.
You know what? We don't seem to talk about the annual assistance anymore.
Well, it's still out there.
Has that become a kind of a dead topic?
It's not dead. It's just that there's limitations as to what associations are able to do. And certainly they should be doing their due diligence, making sure that people that are making the requests for the reasonable accommodation to have the assistance
Can you
animal.
tell people the difference, too?
Well, there's Americans with Disability Act laws on a federal level that applies to places of public accommodation, restaurants, hotels, shopping centers, and that nature. That's one set of rules, and that refers to the support assistance animals or service animals. Service animals is under the ADA, and community associations fall under fair housing, where they use different terminology and different requirements apply. So, under the fair housing laws, support animals, assistance animals are the terms that you use relative to that, and primarily
same thing. Assistance, support?
Well, similar. Under the ADA, there are certain requirements of training, certification, vest requirements. None of that applies in fair housing.
Okay.
In fair housing, it's typically going to be either an obvious issue like a seeing eye dog or an animal that assists with somebody who has obvious impairments. That's one type of assistance animal, but the most that we see are the emotional support animals, which are more from a psychological basis. What's required is the person has to submit documentation from a qualified medical provider. It can be a doctor, it can be a psychologist, social worker that there is an impairment of a major life function by this person's disability. We don't have to know what that disability is, but just that there is such an impairment, has to be a major life function, and that this particular animal alleviates that disability to the point where they can get full enjoyment of the property. And when they've submitted documentation to support that, then the association has done its due diligence and would need to allow that animal to reside there. Assistance and support animals under fair housing, by definition, are not pets. And we're dealing with pet restrictions. So since they're not pets, then they're no longer falling under the restriction, while they still look like a pet,
Right.
act like a pet. And associations can have rules in place on the conduct of the pets while they're there, with limitations that they can't be onerous and they can't be unduly difficult to deal with. They still have access to virtually anywhere the person can go, not in the pool, but on the pool deck. But they still have to conduct themselves appropriately, and they can be caused to be removed if they are causing problems or violating the covenants.
Okay. We got another call.
Hello.
Let's go to the phones. We got Rich.
Hey, Rich.
Hi, guys. Great show.
Thanks.
Thanks for taking my call. I have a question regarding some board members who own multiple units within the condo association that I live in. They are consistently in and out of delinquency on their homeowners association fees, and I believe their documents state that if they're delinquent, they're not allowed to govern. What recourse do I have in that these guys are governing and they're in and out of delinquency? Are they allowed to continue on, and what recourse do I have?
Well, Matt, in each instance, HOA condominium, the statute provides that a board member who is more than 90 days delinquent in any monetary obligation to the association is disqualified from serving on the board. Automatic. They're not on the board. So if they continue to act as if they are, the recourse available to homeowners, unfortunately, is the requirement to file legal action in the courts to compel them to step down. And there is the possibility of prevailing party attorney fee recovery, but it's not a fast process. But it does put everything the association does at risk of being challenged and overturned because unqualified people are making decisions on behalf of the association.
So they need to be delinquent 90 days.
90 days.
90
but the way
days.
that is calculated is while they can become, if they become delinquent in September, they stay delinquent in October, then in November they pay September, where they're only 2 months behind still.
Right.
The delinquency began in September, so that's the starting point of the 90 days. They have to get completely current to start a new clock. So if they never get completely current, you go back to the date of the first delinquency and start your 90 days from there. Once it exceeds it, they're off the board automatic.
I see. Wow, doesn't sound real simple to me. But
No, and if they own multiple units, they
Yes.
any delinquency. So if they're delinquent on one,
Right.
that disqualifies them.
Yes. And so the courses that you were just talking about on the show, are they for people who want to become board members, or are they a requirement by the state after you become a board member?
Actually, both. The law allows for the course to apply to someone who gets on the board if they took it within 12 months prior to getting on the board.
I see.
Then they wouldn't have to take it again. Or if they recently on the board and hadn't been on consistent or continuously and had a certificate from before, then that they would need to do that within 90 days of getting on the board.
Terrific. Well, thanks a lot, guys.
Thanks,
All right,
man.
Thanks for calling.
Thank you.
Wow, a lot of callers today.
Glad to hear from you all.
Let's give everybody your phone number and your website again before we go off the air.
KBRlegal.com. And 800-974-0680. Next month, we're going to have more to talk about on the statutory changes that took place. They've only just been sent to the governor, so at this point, they haven't been fully formalized, but by then we should have a better idea.
Okay.
So look to hear from you then.
Great show. Good seeing you every month.
Likewise.
Hey, we'll be back next week with more Ask the Experts. Have a good week. Peace and love. We're out.
Hey, how come...
Thanks for tuning in today to the Ask the Experts show. Tune in while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on the preceding sponsored program